Thank you, Mr. Chairman. Mr. Beisner, you raised a couple points that I found pretty interesting. You started to explain that there are occasions where it's appropriate for states to engage outside counsel. You talked about tax collection cases. You said they're really the only ones, and those are really like prosecutions. Could you just explain that?
Well, I think what I'm getting at is where you have you may find some room for it where you have a liquidated amount that is owed to the state, so that when you give this to an outside counsel, there's not this notion of discretion that's being exercised in what's being pursued.
I'm sorry, a liquidating amount owed to the state based on what?
If I'm a taxpayer and I owe $1,000 to the state, for the state to get some assistance in collecting that liquidated amount doesn't involve a lot of prosecutorial discretion. I think it's where you get into, I want to prosecute for wrongdoing sort of category, where this gets to be more of an issue.
Right. So if the purpose, in that case, if the purpose is to go after someone who owes money to the state, then I'd suggest that it's worth taking a look, as some of my colleagues have, at the tobacco litigation. The tobacco litigation, I don't need to remind you, was not litigation brought by states in order to punish tobacco companies. The tobacco litigation was brought by states because of the billions and billions of dollars in health care costs that the taxpayers in those states had to pay as a result of the products that the tobacco companies were making. So when those cases were brought in 46 states that settled in '98, the tobacco industry paid more than $200 billion, and without the outside counsel, to think that there could have been some reliance on the small attorney general's office in every state to bring that litigation is outrageous.
Yeah.
And in fact, and I think Mr. Nadler touched on this, you don't have to take our word for it. When R.J. Reynolds' lawyer explained, and I quote, "The aggressive posture that we have taken regarding depositions and discovery in general continues to make these cases extremely burdensome and expensive for plaintiffs' lawyers, particularly sole practitioners. To paraphrase General Patton," he said, "the way we won these cases was not by spending all of Reynolds' money, but by making that other son of a bitch spend all his," close quote. If I, as a taxpayer in the state of Florida, know that the only way that we're going to be able to be compensated for the harm done to the taxpayers, because really that's what this whole hearing is about, right? The costs to our society, then I want to be sure that we do everything we can to make sure that the state will be fully compensated. And if I'm up against someone who has made it his sole purpose to drag out, and with all due respect to Mr. Franken, his crusade against millionaire attorneys, when the tobacco company's own lawyers say that the whole point of this is to drag it out, to make it impossible for the states, and ultimately in the class action suits, to make it impossible for those who have been injured by that product that kills people, then how is it possible that the only time that we could we could possibly permit class actions is when taxes are involved?
Well, I'll make 2 points on this. First of all, in the tobacco litigation, that's not the sort of situation I was talking about, because it was not at all liquidated. There was huge debates about what the causation is there, with a huge amount of discretion being invested in those.
I'm sorry, Mr. President, hold on one second. I don't want to relitigate the tobacco litigation. It's not my practice. I was a real estate lawyer. There's a huge amount of debate about what the causation was for what?
What the relationship was
between smoking and cancer,
and what the health effects were.
Between smoking and cancer. That's still debatable?
Between the costs that were incurred.
Are we still debating that point?
No, I'm not debating. What I'm saying is that between the actual costs that were incurred by the state on that issue. And let me just note, in terms of the states weren't made whole by that litigation, because many of the states then legislated to shut down that sort of contingency.
Mr. Beisner, I appreciate that. I only have another minute. I want to touch on one other thing you said. You said that you're worried about the sullying of the reputation of our legal system. You talked about, in response to a question from one of my colleagues, this idea of pay to play and the correlation between contributions made to attorneys and who is hired as lawyers by the state. I'm just curious if you know the figure, the amount of money that the U.S. Chamber contributed in judicial races across the country. Do you know that figure?
I don't.
And can you tell me why the chamber would contribute to judicial races? Because again, my focus is again on ensuring that the reputation of the legal system is not sullied.
I'm not aware of any circumstance in which the chamber has been asked to retain by the state to
No, I'm not either. I'm not either.
obtain
No.
money.
Okay, I yield
from
back,
lawsuits.
I yield back, Mr. Chairman.
I thank the gentleman, and